Today I'm meeting with Ed Carter, a professor of communications and also a lawyer, and we're going to discuss the Utah Code of Judicial Administration Rule 401.01 about electronic media requests and media in the public courtrooms. All right, so those of you that have seen these other programs before, we're just going to talk a little bit about various opinions that people will have, things you may have heard about, and where this rule fits in the general openness to the public of the courts, as well as the concerns about the parties or the participants and how we can balance those so that public court proceedings can be made aware of to the public, while at the same time making sure we don't interrupt the functioning of the courts properly. So before we do anything else, we haven't talked in advance or anything like that, but what are your initial impressions or your opinions or comments on the rule itself?
Well, I think it's great because 5 or 6 years ago, Utah had one of the least progressive rules as far as electronic media coverage in courtrooms. And with this relatively recent change in the rules of judicial administration, Utah has now one of the more open rules in the country as far as allowing electronic media coverage. And I think that's a good thing. You alluded to some of the reasons why electronic media coverage can be a positive thing. It can actually increase trust in the court system and educate people about what's going on in their courts, and I think it's great.
So, do you know anything about the history of this rule, or kind of the concerns that brought it about? Was it because there was embarrassment in Utah that we were looked upon as being behind the times, or was there a real desire to make more people aware? What was the impetus for the rule as we know it now?
Well, I mean, I have my perspective on that. Obviously, others who've been involved in the process may have their own views about it, but I don't think it was necessarily embarrassment. I think there was a genuine desire to say that let's make the courts as accessible to people as possible. You know, if you go back in history, going to court was a public spectacle. People would go and watch for entertainment purposes. Obviously, with digital communications technology now, you don't need to go down to the courthouse, and so it's really, I think, an effort to increase the accessibility of courts and the people's understanding about the court system and the public trust in the court system. I actually think it benefits the court system for people to be able to see what's going on, know how tax dollars are being used, and understand how disputes are resolved.
What about the concerns over making it available through digital means, turning court proceedings into more of a circus, or having them be treated with less gravity?
Well, it definitely is a concern. I mean, I worked as a journalist for several years, and so I'm aware of the processes that go, and I covered the court system. And, you know, I think that the judge in a particular case is probably going to be rightfully concerned about the impact of media coverage on the proceedings. Now, that's not to say in every case there's a problem. In fact, the rule states that there's a presumption of electronic media coverage, and so we presume that all cases are open unless there's some reason not for that to happen. So there are some real concerns about the impact on the process itself, but there has to be a showing of a specific problem.
It's a beautiful segue then. So there's a presumption of coverage. What would be some of the reasons that you've encountered, whether it be in case studies or as a journalist or as an attorney, or now correct me if I'm wrong, you were involved with the administrative office of the courts and there? So
I was on a media relations committee that is in the administrative office of the courts that dealt with some of these issues, and there were judges, media representatives, public information officers from the court system itself. And so, you know, we frequently discussed the positive as well as the negative aspects of the rule.
You're particularly well versed, and so what were some of the things where the media was doing more harm than good? Can you think of a specific example, whether it be in this jurisdiction or elsewhere?
Sure. Well, there was a pretty well-known case where a still photographer had taken a picture of a court proceeding and was able to zoom in on a portion of a specific document that hadn't been admitted as evidence, and so the judge was concerned that this was going to prejudice the outcome of the case, because, you know, it was published on the front page of the newspaper, and it was it was related to the issues in the case, but again, hadn't been admitted as evidence. And so, the judges in that case are going to be worried, obviously, about impact on jurors and whatnot. Of course, jurors can be instructed not to watch news and pay attention to media, but
even if they had completely kept that from the jury, the fact that the reporter or cameraman had basically violated the trust of the court. Say, we're allowing you in here. Yes, you have rights under the Constitution to report the news, but you're reporting something that really wasn't public at that point.
Yeah, well, and I would probably say, in defense of the journalist, that it wasn't necessarily clear that he couldn't take a picture of the document, because now the rule of today speaks to that issue, and I think it was probably because of that, maybe because of that specific case. But so I don't necessarily think the journalist was out of line. It was in a public courtroom. He was allowed to be there, and was able to take a picture that was in view of public. Now, the fact that technology allows you to get zoomed in on that is a different kind of thing. But the rule, does address that now, to say that there could be some restrictions on taking pictures of documents. I mean, specifically mentions that, documents that are not admitted into evidence.
Right. What about concerns? Because I know that one of the big things that would immediately pop up, whether it be among jurists or members of the public, would be, well, I don't want my court case splashed all over the news or splashed all over the internet. So how do you balance privacy interests against news gathering and public broadcast of the news?
Well, that's, to me, the key issue, is there does have to be a balance. And as an attorney, I was recently involved in a case where that issue came up, and I was representing a media organization arguing that in the public court system, if you're going to resolve disputes in the public court system, that's done in public. And there are historic and other reasons for that. I mean, it can actually be a protection for the litigants to have things done in public, so that, there's not secret justice processes going on. Now, at the same time, there are legitimate concerns about privacy, but at least in that case, my argument was, well, closing off entire case files is not necessary, but there can be targeted approaches to say maybe there's a portion of the document that could be redacted or something like that. But that generally, again, the presumption is one of openness. And so, there are private dispute resolution mechanisms that people can resort to, but once it comes into the public court system, that's done in public.
And let's ask some of the obvious questions. So if a case is open to the public, you or I can just walk in and have a seat. Nobody asks us what business we have there. Nobody can tell us we can't be there. It's open to the public as long as we behave ourselves and don't yell and scream or do anything like that to disrupt the proceedings. We can watch the whole thing in all of its gory detail.
Yeah, that's exactly right. And as I said, in history, when people would go and see court processes happen, there might be large crowds there. Today, you don't necessarily see large crowds in the gallery of a courtroom, but giving media access essentially is that same function of allowing the public to view that. I mean, most of us are not going to go down to the courthouse, but we might turn on court TV, or we might turn on some other outlet for gaining access to those proceedings.
So what about people saying, well, I think that my case I'm not a public figure, and so my case just isn't newsworthy. It's just common. You can see many cases like mine in a given day or given week or month. So because my case is so common, that's what makes it not newsworthy.
Yeah.
What do you say to an
well,
argument like that?
yeah,
what are the arguments to something like that?
It is an interesting argument, and I can understand that maybe somebody who's in a what they consider run-of-the-mill proceeding might think, why is attention being brought to my particular case? Now, I mostly come at it from a news perspective, and so I would generally apply a newsworthiness standard to say, okay, if we're going to be covering a case either in writing or in broadcast, there's some public interest in doing that, but the right exists to walk in any day and cover any case. And there might be public benefit in knowing just what goes on in a run-of-the-mill case, not just in the high-profile cases. So I would argue that anything that happens in a public court system is potentially newsworthy.
Yeah, in fact, what would make something not newsworthy? I mean, I guess the question I have is, how plain Jane would it have to be before someone could say, I see no newsworthiness to reporting on a public proceeding? it would be hard to say, because at that point it's kind of like who watches the Watchmen, right?
Sure.
Like, wait a minute, if you're the subject of the news and you're the one that also can determine it's not newsworthy, I could see situations where someone could say, well, actually, we do have a viewing audience that finds this of interest. I mean, just like you pointed out, I practiced law in a little tiny town where, even though it was, 1997, 98, it was still something where people would, on occasion, come to the courthouse for entertainment purposes. The internet was still kind of in its infancy, and so I remember I talked to older attorneys, and they'd say, "Oh yeah, we used to really pack this room." So, what about? And it was just because their neighbors might have been something like just a boundary dispute. It might have been something kind of humdrum, but they still wanted to know what was going on because it affected their community. But what about something where it's just like a preliminary hearing in a criminal case where it's like, look, you can see hundreds of those. You've seen one, you've almost seen them all.
Sure. Yeah, well, again, I mean, I think there are reasons to have that be open and accessible and even open for media coverage. Like I said, there is a protection to the defendant in that kind of a situation to have people be able to see what's going on. And I actually think that the higher purpose is to have us all understand how courts resolve these disputes. How does the judge do his or her job? How does the public defense attorney function, the prosecutor? I mean, those are all folks who, one way or another, are supported by public funding. And so, maybe the focus seems like it's on the defendant, but I actually, when I look at that stuff, I think, well, I want to see how the court system is functioning itself and how's it resolving these disputes.
I wonder sometimes if there might be a benefit to somebody who says, well, I have been charged with a crime, and I don't know what to anticipate. I wonder if there's some place where I could go to see what's coming up.
Sure.
See any benefit to that?
Sure. I think so. Yeah, I think there's definitely an educational benefit to that. I mean, in all of this, I think that it is important, and there is a responsibility for anybody who's doing media coverage to act in the public interest. Now, drawing that line is really difficult, So if somebody's producing and selling CDs of court processes because they want to make a lot of money, well, I mean, that probably is hard to say no, that you can't do that, because the rule is written in such a way that, if it's media coverage and there's some sort of public interest, even if they're selling them and making money, that might be okay. But that would probably raise some concerns in my mind, just to say, well, let's think about the motivation of the person doing the media coverage. But like I said, drawing that line is difficult because journalists also are involved in a business.
That's what I was going to say. I mean, I agree that to just my non-lawyer mind and heart, I might go, yeah, gee, I mean, going in and filming people's disputes and conflicts and embarrassing moments for profit.
Right.
Well, that doesn't sit well with anybody, I think, with a conscience or any sense of decency. But at the same time, when you deal with commercial media outlets, they have to sell advertising to keep the lights on and to show the news in the first place.
Yeah. So
and let's face it, if it bleeds, it leads, and things like
That's
that.
right.
I mean, there's a lot of things that might be very interesting that nobody will watch.
Yeah. No, and that's why I say I'm not one to necessarily try to draw the lines too carefully or too closely to say, okay, this person's doing journalism and this person's not, because I think the definition of what constitutes media coverage in the public interest could be pretty broad.
What if it's a non-profit organization? Should that make any difference? Somebody says, "Oh, we don't want to make any money."
Mm-hmm.
I mean, I got to be honest. I'm thinking, open to the public is open to the public, and if the rule had been, if they wanted to write the rule to say, no, we want it to be a more academic or a purer pursuit. Yeah. I'm kind of going, well, then so long, channels 2, 4, 5, and it'd be. And 13, of course, not to be. We don't want to exclude anybody. It'd be, well, we don't find that your enterprise is sufficiently dignified or something like that. And then, okay, well, what if it's your audience isn't broad enough, or what if what if we find that your programming, if the court's like, well, you seem to focus on just one thing or one judge or one county. I mean, I'm just kind of thinking, well, then, if there's a need, wouldn't that be where another channel arises?
Sure.
So I'm just kind of wondering.
Well, I mean, my idea is that we have this marketplace. Actually, I didn't come up with this, so I won't say my idea. But what I believe is there's a marketplace of ideas, right? So there should be competing forces that are allowed to enter in and kind of let the market take care of it. I mean, the whole theory of the First Amendment is that the government shouldn't be the ones telling us who can speak, who can publish, who can broadcast. Now there are some restrictions, obviously. To get a broadcast license, you have to go through the FCC. But with technology today, somebody can pop up and say, you know, the news organizations that are out there, they have their function, but there's a niche that I'm going to fill that I think is important. And if the market will bear that, you know, then I think that's a positive thing, that we have more competing voices in the marketplace, more sources of information. And then the market will decide, you know, if it's not a quality source of information or if there's a problem there, that'll eventually get sorted out.
What about concerns over certain kinds of cases? Let's start with criminal, for example. What if somebody is charged? In fact, and I'm a candid person, and some people would say almost indelicately candid, but you know, it seems like you can almost count on a high school teacher or gym coach being charged with some kind of child molestation almost quarterly. It almost seems like you do a Mad Libs where you could just fill in, this teacher at this school has been charged with doing this to this person. But then, I mean, I remember when I was going to high school, that happened to a coach in my high school, and it was made up. But this coach's life was ruined because the accusation was made public, some of the court proceedings were made public, the initial appearances and things like that, and then it was discovered that this student had made allegations because the student was upset and not because anything bad had happened.
Yeah.
This had all been published, and I know, again, you are someone that already has heard this 1,000 times.
Sure.
And you know, but for people watching that don't, there's a lot of people that would say immediately, it's like, yeah, you know, that's not fair, or I might know somebody like that.
Right.
Why should that be open to the public? Why should we allow the public to hear about something when, in fact, when it all comes out in the wash, this person was innocent, and had he or she not been exposed to the media, this person might have been able to keep working or not have to move or you know, or whatever. What do you say to that?
Yeah.
What are the arguments on both sides, or whatever you feel is important?
Sure. Well, I think it's a perennial issue to be concerned about because it does happen. I remember a movie called Actual Malice. I'll use a movie reference here. Paul Newman is...
Absence of Malice.
Yes. Absence of Malice.
I have never seen it, but I do remember.
The concept of actual malice is at the heart of the movie, which is, you know, how much knowledge does the media organization need to have before being liable for causing harm to somebody's reputation. And so, anyway, Paul Newman makes a comment in there. He's reported on as having committed a murder that he didn't commit. The prosecutors knew he didn't commit it, and they were sort of setting him up to flush out the real killer. Anyway, he says, you know, when you report on the original accusations, it's on the front page in big headlines, but when I'm exonerated, who reports on that? You know, and so sometimes there is that phenomenon. If somebody's cleared, ultimately, I would hope that as journalists or media organizations or public generally, that we give as much attention to the ultimate acquittal of somebody as we would to the initial charges. Now, the reality is maybe that doesn't always happen, but what I think is more speech is better than less speech. So instead of suppressing, you know, the original accusations, if they're made in a public court and there are charges filed, then I think, yeah, that needs to be covered. But let's also cover if there is an acquittal.
The question that arises in my mind is like, okay, so we don't cover it until the point where everything explodes, and now everybody's rushing to catch the public up on what's happening, and then there's a chance that people might not pay attention to that either because there's not enough time. So let me ask about this. Children are a big issue, right?
Sure.
We see that too. So what about arguments about protecting children in any setting, whether that be a civil suit or a criminal suit? Now, again, I have my opinions. I'm a parent. I don't like to see children harmed, but at the same time, is there a reason to make children an exception to media coverage?
Well, I could certainly see reasons to do that, yeah. And I think the Utah rule actually balances that fairly well and says that a judge can restrict, coverage of minors. I mean, the fact is minors do sometimes testify in court or are charged with crimes in the juvenile system, and so those are also court processes. But there are limitations. You know, for example, in juvenile court, it's not as open. Sometimes there are reasons for it to be open, but you don't just walk in and have a presumption of media coverage or even openness to the general public. And identities are sometimes concealed using initials and things like that. So the court system, I think, has adapted to protecting minors and their interests, and to me that's totally legitimate. You know, a judge could say to somebody filming in a courtroom, you know, don't film this particular minor, and just like they say that about jurors, you know. So there are some parts of the process that I think are legitimately excluded from public broadcast. Sure.
So overall, with Rule 440101 being as it is, any concerns over the rule? Any places where you see it can be abused either by the news media, or by the courts, or by litigants themselves who might have said, before I knew about this rule, I just figured it was like show up to court and that was the end of it. But now maybe I can exploit this. Can you see how it could be exploited by any participant?
Yeah, well, I think the potential is always there, and the reality is that there will be excesses. You know, the news media will do something, or a party might do something. In the end, though, I think the rule is written really well because it's flexible. It gives some discretion to the judge, but it says specifically that a judge can't deny electronic media coverage based on personal preferences. So if a judge just says, I don't like it, that's not a reason.
But let's specifically drill down to the part where they have to make particularized findings, from the case itself, and can't just make a general objection. Because what if someone were to say, well, I'm concerned about the media being here because it might prejudice somebody, or it might violate someone's privacy, or it might harm a child.
Sure.
Couldn't that be said of any coverage? Yeah. I mean, like you say, where do you draw the line? How do you know that what you're doing? Somebody could, with a complete, with no nefarious purpose, go in and catch something just by virtue of having a recorder or a camera on.
Sure. Yeah.
So, I mean, if we want to make sure that nothing could possibly go wrong, why not just bar everybody from the court? Because you and I can go into court and we can go out and tell everybody lies about what happened, right?
Sure.
Hey, guess what happened in court? Well, the guy sang like a canary, and he told everybody where the bodies were buried, and then it's like, that's not what happened.
Right.
Well,
the rule does use the phrase a reasonable likelihood. I mean, you talked about the judge has to make these specific findings, but there has to be a reasonable likelihood of harm that will occur, and so now that phrase can be subjective, but I think that at least sets a bar that says, okay, it can't just be speculative. I mean, if there's a wild potential out there for some harm to come, that's not reasonable, then the judge can't base his or her decision on that.
For example, would it be harmful to say, well, covering this might expose this criminal defendant to a lot of public scrutiny and what's the word I'm looking for? Or defamation, things like people, and then it turns out the guy's innocent.
Right.
And we don't think that this suffering would have been so bad if it hadn't been published. Or this civil suit. People learned about an impending merger as a result of this that otherwise wasn't public. This child's parents' names came up, and now that child at school, some people came up and teased him because they found out his parents are getting divorced. What about those situations? Hey, we're going to talk about if the secret formula has been misappropriated. What do you do in those situations? Do you just say no coverage because I don't want to be responsible as the judicial officer for doing more harm than good in the course of this trial?
Well, I think the judge's primary responsibility is to preserve the integrity of the process itself. So some of those things that you're referring to I would consider to be external. I mean, the impact on somebody's reputation because of a court proceeding is not internal to the process itself. So the judge really should be thinking about how do I guard the integrity of the process. So if media coverage is going to, cause jurors to vote to convict somebody when they shouldn't.
It's going to affect the impartial administration of justice. So yes, you can be a judge and be concerned about other things, but hey, if it's not interfering with the process, even if some child does get teased, did that result in the case being administered improperly, unfairly, inaccurately? That's an interesting point. I haven't thought of that.
I think that's, to me, the core of the rule is that the judges are empowered to protect the integrity of the process, but they can't control everything that externally happens. And you know, I would argue that a lot of those external things could likely happen regardless of media coverage. I mean, the fact is that people are aware of things going on. You referred to sometimes people do show up in court to see, hey, what's going on with my neighbor? And so regardless of media coverage, those impacts might be there anyway. And I'm not advocating, you know, harm to children or people's reputations or anything like that, but I'm just saying some of that is sort of endemic to the court process. And the media coverage may amplify that a little bit, but it didn't necessarily invent that.
Along those lines, is there a difference between, say, well, okay, but there's a difference between people coming in and filling the benches in the gallery, which might hold, say, 100 people, or or more or fewer, and having it available to potentially millions or billions of people that could watch online or on TV?
Well, I mean, there is clearly, obviously, a difference there in terms of the size of the potential audience.
But through the lens of, okay, but is that the court's consideration? I mean, again, with jurists, I guess juries, I should say, that might be a problem because the jury might. Well, actually, the jury's there, so they're seeing the same thing that the press is seeing. But I don't know. Maybe it's possible that public pressure. I can think of a scenario where maybe there's a commercial dispute, and then because everybody hears about it, there's a Twitter campaign or something like that where this restaurant says, well, we had a controversial policy and now billions of people know about it, and we're going to change where we would otherwise not have, because legally we could have prevailed, but public pressure is so great. I mean,
the reality is that in today's world, things that go viral can have a huge impact, you know, beyond really what we would have imagined previously. So there are real impacts to that. I mean, you might film something happening in a courtroom that is particularly strange or embarrassing, and you know, gets millions of views on YouTube, and there is probably going to be a huge impact because of that. But you know, I would probably just still argue that if things happen in a public courtroom, generally, again, the presumption is one of openness, and there are going to be impacts that happen.
And you make a good point. You also, because there can be negative impacts, but there can also be positive impacts that never existed prior to this rule. And because let's face it, I'm not going to be naive. Clearly, there will be some judges and commissioners that will say, I don't like having that level of scrutiny available to the public. I used to operate in relative obscurity. But again, I think that's a good thing, because what happens is, if I knew somebody was following me around all the time, I would be on better behavior more than likely. That's not to say this rule exists for that purpose, but it might be a beneficial fringe benefit.
I think so. I really do. And you know, I would also just again reemphasize, I think there is responsibility for those of us, you know, doing media coverage, to think about the long term and, you know, preserve the opportunity for this to continue. I'm sure some, like I said, abuses and errors and excesses will occur, but on the whole, if we're thinking about the long term and thinking about the public interest, then I think it will generally work out. One interesting part of the rule talks about pool operations, and I've had some experience with that when multiple media organizations want to cover a particular hearing, and how the pooling system
So do we allow
works.
all 17 different cameramen and reporters all into the room at the same time then?
Well, generally the rule says no, that you're going to have one still camera, one video camera, and that those folks operating those, exactly, those are going to be shared with the other interested organizations. And so I think that actually works quite well. It reduces the, you know, impact on the courtroom itself and the process, and then it's widely distributed and made available. And so that obviously requires some cooperation among organizations that may want access to that video, but I generally think it works pretty well, and it's a good thing.
Is there anything in Utah's rule that makes it particularly special or unique, or is there anything that's conspicuously absent from Utah's rule that most jurisdictions follow?
Well, like I said,
I don't know the answer to this question.
Well, I think I view it as it's on the progressive end in terms of being relatively open compared to a lot of other rules. One of the reasons is that it has a presumption of openness for all cases, and excepting juvenile cases. And then there could be some exceptions to that, but we don't necessarily in Utah carve out specific areas where we say, well, criminal cases are a little different, or maybe domestic cases are a little different, but there's just a presumption of openness to court proceedings, which I think is, particularly, as I say, open.
And more elegant. I mean, every time you create an exception, then it's like, okay, and then the exceptions upon exceptions or things like that.
Sure, and the message that gets sent to litigants, judges, lawyers, and parties is just the court system is open, and you should presume that.
One other question then, as we conclude, because I'm grateful for you taking the time to do this. Should there be a standard by which the definition of news reporter be determined either by rule, by the court? I mean, as you read the rule, who is a news reporter and who is not?
Well, this is a great
Let me give an example.
question.
So my neighbor and my other neighbor are getting in a fight, and I love to antagonize the neighborhood, so I decide to come in with my tape recorder and camera, and I'm just going to put this up on my Facebook page, and I'll never set foot in court again, but I really can't wait to see. I want to stick it to these guys. Am I not a news reporter, though?
Well, the rule talks about the definition of a news reporter, but it's a functional definition. So it's
under the rule, as you understand it, would I be able to do that? And by the way, nobody knows that. Only I know that, and maybe a couple of my friends. So I come in and I Your Honor, I'm a journalist. I'm here to record. I mean, is there anything that the courts can or should do to vet people that claim to be journalists?
Yeah, well, it is built into the rule a little bit, because even though the presumption is one of openness, the rule says that you should make a request, and it generally should be 24 hours before the actual hearing, unless there's some specific exception that's warranted. But so the court system will have at least 24 hours to look at the request. And again, I don't think the rule establishes micromanagement by them to say, well, this is a bad journalist, or I don't think this is a legitimate journalist, but there's probably a little vetting that goes on there in terms of just, okay, is this person gathering and distributing information in the public interest? And the rule says for the primary purpose of distributing news to the public. So, in the cases that you were sort of bringing up, where somebody has an axe to grind or a specific reason that they're going to do this, not to distribute news to the public, but to embarrass their neighbor, or in a domestic case, to harm their ex-wife
or
whatever.
Just pick on one particular judge. I'm here every day. I'm filming every minute you're in court, or something.
Yeah, I mean, I wouldn't think that's distributing news to the public, and so I think in that case the court would be able to say, no, we're going to deny the request and make a specific finding as to why that's the case, and so there is going to be a little vetting going on. But again, as to the definition of a journalist, I mean, let's say that you haven't gone to journalism school per se, or you're not part of the local chapter of the Society of Professional Journalists. That doesn't exclude you from doing journalism. I think that people can do journalism without necessarily having gone to school, received a degree, or being part of an organization, because it's a functional definition. Are you really gathering news to distribute in the public interest? And if so, you're doing journalism.
Should participants, whether they be the litigants or the witnesses, have a say in whether there is coverage?
Well, generally no. I mean, I probably realistically would say that they can make their arguments to the judge, and they do that.
Does the rule allow them to weigh in on that? Does the rule say that the desires of the participants can be considered?
Yeah. Well, I don't know that it really accounts for that in great detail, but I mean, again, functionally, I think a judge probably is going to take that into consideration. If a party makes a specific argument, going back to the criminal context, let's say the coverage of the preliminary hearing is out of control, there's a lot of media interest and everything, and the party says, okay, but we are potentially going to have a trial in a few months, and so what's the impact on the jury pool? And the party might say to the judge, can we in some way, restrict this? Now, I don't think that automatically means the judge should do it.
So a restriction as opposed to an outright ban? Like maybe we could not mention names.
Yeah, there might be some reasonable approach for the judge to say, let's not allow coverage of some particular portion of it, but there would have to be a pretty high showing, again, because a speculative harm is not enough. It has to be reasonable, and so I think in any preliminary hearing there's a potential for an impact on the jury pool, but there are other things the judge can do, like instructing jurors when they're selected, not to watch media coverage and to base their decision on evidence presented in court, not on past knowledge of the case. And so there's actually a funny skit. I'll mention this. It was on Saturday Night Live. It was about O.J. Simpson when he was in Las Vegas and had a robbery case. So not the original murder case in California and all this, but exactly. Yeah. So Saturday Night Live does this skit, and they're selecting a jury, right, in the skit, and they're trying to find people who won't be tainted against O.J. Simpson. So they've never heard of O.J. Simpson. So they get an Iceman who's been frozen for 5,000 years, and a guy from Mars, and a hermit who's been in the backwoods for 25 years. So the point is, you're probably not going to find people who haven't heard of high-profile cases, and even if you could find them, that's not a representative jury pool, and you probably wouldn't want them on your jury. And so
because they're so out of touch that they may not even understand the context of the case.
Yeah,
if you're from Mars, you may not have any concept of what we're dealing with here.
So the point is, in high-profile cases, jurors, they can have some exposure to the case and yet still be fair and do a good job. And you can find that out through jury questionnaires and careful selection of the jury and everything. And so I think the fact of media coverage doesn't automatically mean there's a problem.
Interesting. Well, I appreciate that. And you've done such a great job of articulating that and done it so clearly and in relatively few minutes as well. I'm so grateful for that. Thank you for being with us, and we hope you found this useful as well.
Thank you.